Hello, my name is Carina Kraatz. I am with Kitch, Drutchas, Wagner, Valitutti, and Sherbrook in downtown Detroit, Michigan. I am a partner who focuses her practice on commercial litigation and bankruptcy and insolvency issues. I am pleased to present the webinar on bankruptcy and insolvency basics for creditors and debtors. Before we kind of jump into what bankruptcy is, I think it's important to point out COVID's impacts on small businesses. For example, the loss of customers, loss of production, and inability to operate. Unfortunately, we're all aware of how much the shutdown has actually impacted small businesses, put many businesses out of business. In fact, in the United States, commercial bankruptcies are actually up 33% over last year at the same time. While individual bankruptcies are down, this will be affected greatly when different government assistance and moratoriums are lifted that are in place until the end of the year. So what is bankruptcy generally? Generally, bankruptcy is a legal process in federal court in which a debt is either eliminated completely or repaid based off of a court-approved payment plan. There are three main types of bankruptcy for individuals or businesses. There's Chapter 7, Chapter 13, and Chapter 11. The reason I list Chapter 7 and Chapter 13 first is that those are two different types that individuals mainly file. Occasionally you have an individual filing the Chapter 11, but that is because they are above the debt and income level for Chapter 13. Businesses, on the other hand, are known to file Chapter 7s and Chapter 11s. A Chapter 7 bankruptcy is a straight-out liquidation of debt type bankruptcy. And if a business were to file a Chapter 7 bankruptcy, generally the business will cease operation because it's not paying back any of its debt, there's no reorganization plan, and it just stops operating. This is typically filed in accordance with the dissolution as well. For an individual filing for Chapter 7 protection also does not pay any of their debt back, and the process lasts about 3 to 4 months generally. One important thing to note about filing a Chapter 7 bankruptcy is that in order to do so, in order to have the ability to not pay any of your debt back and receive what's known as a bankruptcy discharge, which is a court order saying that you don't have to pay any of your debt back, you have to qualify to do so. In order to qualify, you have to pass what's called a means test, which is a test which takes into some of your income, which we will talk about on a later slide. The types of businesses that are eligible to file a Chapter 7 are sole proprietorships. The reason that a sole proprietorship can file a Chapter 7 is because it's considered an extension of the individual. And they can also receive that discharge or that court order saying that they do not have to pay any of their debt back and that creditor cannot come after them. A partnership and a corporation, they can file a Chapter 7, but they don't receive a discharge. A lot of times this is why you potentially see them filing a different type of bankruptcy or just going for a dissolution instead of bankruptcy and staying outside of the court. One important thing to note is that when somebody files a Chapter 7, there's an automatic stay or an automatic hold that gets placed onto the bankruptcy estate. The bankruptcy estate is basically all of the debtor, who is the person or the entity filing, all of their income, all of their assets, all of their liabilities. So while a person who files for Chapter 7 protection, they can still work and make money, all of their creditors can have to stop collection activity against them due to that automatic stay. If they continue to attempt to collect, then it is a violation of the automatic stay. So it's something that a creditor has to be very well aware of if they know of or have been directly informed that either an individual or an entity has filed for Chapter 7 protection or some other form of bankruptcy protection. discussing more about the means test. The means test, as I spoke about briefly, determines if you're eligible for Chapter 7 forgiveness of debt, or if you have to repay some of it. It takes into account monthly income, acceptable monthly expenses, and family size to determine whether or not you have to repay some of the creditors. So if you're not eligible for Chapter 7 bankruptcy, you'd be looking at a Chapter 13 bankruptcy. So Chapter 13 bankruptcy is a payment plan type bankruptcy. So over 3 to 5 years, you are making payments to the court via your assigned trustee, who is working on behalf of creditors in limited circumstances, or working on behalf of the court. So they're basically assigned by the court to administer the bankruptcy case. And so all of the payments go into the trustee, and the trustee is sending those payments to secured creditors or administrative expenses or unsecured creditors if they're receiving a payment from the plan. So if somebody isn't eligible to file for that Chapter 7, they file a 13. And the main reason that people don't file a 7 and end up in a 13 is income level. They just don't qualify. It doesn't mean that you can't file bankruptcy. It just means that you make enough money where Congress, when enacting the bankruptcy laws, said you have enough funds to pay something back. So, how does this payment plan come into effect? Your attorney will, based off of different claims that have to be paid within the bankruptcy, determine your bankruptcy plan. Or your bankruptcy payment plan. Now, one thing that is important to note is that this can be on a monthly basis or some other basis, like weekly or bi-weekly. For an individual filing for a Chapter 13 protection, it is typically based off of when they receive their paychecks. So this payment plan is filed with the court, and it has to be approved by the court. Now, who gets to object? Who gets to say, I don't want this payment plan, or I don't like how I'm treated as a creditor in this payment plan? There are a couple of different entities who can actually object. First, and the most commonly objecting party, is actually that trustee. So the trustee, remember, is the one who is reviewing all of the payment plans, and then also administering the bankruptcy estate. But in doing so, they're also reviewing the debtor's income and their other monthly expenses and their assets. And so they're looking at, can the person for filing for bankruptcy protection actually pay back more than they're proposing? That's a common objection. Creditors also have the ability to object to a bankruptcy plan as well. And so they would file their objection with the court reviews it, and at that time, just as well with the trustee, that creditor would have the ability to potentially work out that objection with the debtor, or take it before the judge, and the judge will rule on whether or not that plan should be ordered by the court. Because once the repayment plan becomes ordered by the court, then it can be modified in certain circumstances, with the debtor typically filing for an amendment of that payment plan. An important thing to note is that only after the debtor makes all of the payments, then the debtor can receive a discharge. So over either that 3 or 5 year time frame, and the debtor's made all of their payments and conformed with all the other portions of their plan that they have to, only then will they receive a discharge. Now, because a Chapter 13 lasts 3 to 5 years, the success rate of a Chapter 13 bankruptcy is unfortunately a lot less than a Chapter 7. So there's a lot less instances of a debtor receiving their discharge in a Chapter 13 or a 7. And that's partly due to time, circumstances change, hardships change, etc. The next type of bankruptcy that we have discussed previously is a Chapter 11 bankruptcy. Chapter 11 bankruptcy is also known as a reorganization bankruptcy. a lot of times you hear corporations had filed for Chapter 11. Unfortunately, after the beginning of the pandemic and the shutdown across the nation, you heard a lot of different retail stores filing for Chapter 11 protection. And so you see a lot of partnerships and different types of corporations filing for Chapter 11. Very similar to a Chapter 13, a plan of reorganization is filed with the court by the debtor. So again, this is another plan by the debtor in which they seek court permission to reorganize their debts and their liabilities and their operations moving forward. So very similar to a Chapter 13 plan, you also have creditors who are able to object to that plan, to say, no, I should be treated this way versus being treated lower on the totem pole, so I want a higher prorated amount of my debt if, for example, that debtor is saying, I want to pay back less, or I want to pay back in the future, or I don't want to include an interest rate. So there are different things that a debtor can propose as far as debt that a Chapter 11 creditor can object to. An important thing about a Chapter 11 bankruptcy versus a Chapter 13 is that creditors have to vote to approve the plan. So a Chapter 11 creditor is actually more involved in the program, in the plan, than a Chapter 13 creditor. It's also important to note that in bankruptcy, a contract or lease can be either rejected or accepted. And this is true regarding a Chapter 7, a Chapter 13, or even a Chapter 11 bankruptcy. And we'll talk about that a little bit more in detail later. So we've talked mainly about some debtor issues in bankruptcy, but what are the creditor issues? So for example, you just received notice that a customer is insolvent. Now what? Now what do you do? Unfortunately, the attorney answer is, it depends. It depends because it depends on the type of the bankruptcy that was filed. Is it a Chapter 7 bankruptcy? If it is, and it's a straight out liquidation of debt and they qualify for it, then you're looking at potentially getting zero of the funds owed to you back. Now there are some caveats to that as to whether or not there are assets that aren't protected by the bankruptcy estate, or if there is some sort of fraud that you can allege. So to keep your debt what's called non-dischargeable, meaning that the debtor would not be free from personal obligation to pay that debt back. Another thing that a creditor will have to do is file what's called a proof of claim. A proof of claim is necessary in a payment plan type bankruptcy. So we're looking at the Chapter 13s and the Chapter 11s. So in order to get paid, you don't get to just sit back. You actually have to do work. And once you submit your proof of claim with the court, either the trustee or the debtor themselves can attempt to object to your proof of claim. So just how you have the ability as a creditor to object to a debtor's proposed repayment plan, the debtor has the ability to object to your claim for funds. Now, it's important to note that just because you, as a creditor, submit a proof of claim to get payment from the court doesn't mean that you're going to get 100% payment from the court, and it doesn't mean that you're going to get payment now. It depends on what the terms of the debtor's plan has your claim listed as. I referenced earlier that there are administrative claims, which are paid very first, they're top of the totem pole. Then there are secured claims, and then there are unsecured claims. Mixed in with those, there are priority and non-priority claims. And so depending on how you can have your claim categorized depends on how soon you're able to get paid and potentially as to what amount if the debtor's plan does have a proration of your debt category. So as an example, in Chapter 13 filings for individuals, very commonly unsecured debts like medical debt or credit cards are the very bottom of the totem pole. So They are unsecured, non-priority debt, which means that in that Chapter 13 payment plan, that debtor is trying to pay them back basically zero or the bare minimum. Another item that a creditor has to be aware of is that leases and certain types of contracts can be either rejected or resumed in bankruptcy. And so you have to be aware of what type of contract that you have and what the debtor intends to do with that. Also, a creditor may run into preference issues. A preference is a transfer of interest that by the debtor made within 90 days prior to filing. What does that actually mean? So in the 90 days prior to a bankruptcy filing, the law presumes that a debtor is insolvent. What's important with that and that 90-day time frame is that then a trustee is the most common party, will say, okay, who did that debtor pay back within the 90 days prior to filing? If they paid back a large sum of money to bring an invoice current so that they didn't have to include that creditor in the bankruptcy, then I'm going to deem that a preference. And I want to pull back that preference. I want to get that preference for the bankruptcy estate. And so that I potentially have, as the trustee, recovered those funds paid by the debtor to the creditor within the 90 days prior, and then distribute them on a pro rata basis to all of the other creditors listed in the bankruptcy estate, so that each creditor at that level receives the same amount. Now, you're thinking, I got a lot of people that pay me right before they file. What do I do? I can't turn over all of this money. If I do, I might go bankrupt. There are certain defenses available to a creditor when somebody seeks a preference payment from them. And again, that preference payment is just payment received within the last 90 days prior to filing. Some examples are, and these are the big three, so to speak, is a contemporaneous exchange for new value. There's also subsequent new value provided. And then also the last one of the big three are payments made in the ordinary course of business. So for example, hey, I didn't call them and say you have to bring your $20,000 invoice current now because you're filing. It's you were making $20,000 payments because that's what your regular payment is in your ordinary course of business. In a continuation of the creditor issue, so what about goods that are in transit or being delivered to an insolvent customer? So this is a situation where you are supplying goods or other products to a customer. You find out that they are insolvent. What do? One of your options under the UCC, and that has been incorporated in the bankruptcy code, is you can actually stop the delivery of those goods. Or you can stop the delivery of those goods if the buyer repudiates or fails to pay for the goods prior to delivery. So if you become aware that your buyer has become insolvent, you can say, nope, I'm not going to deliver those. They haven't paid for them. They're still mine. They're not going there. But what happens if you find out after the goods have already been delivered? You can refuse to deliver the goods unless the cash payment is made at the time of delivery. This is why you have a COD basis that is frequently employed by suppliers. It's also frequently used in bankruptcy as well. So then as you're providing the products, you are also getting payment. Additionally, you have the option of reclaiming goods as have already been received by your buyer. So as a creditor, what do you do when you have leased equipment on site of a customer, we'll call them, who has gone bankrupt or who is insolvent at this time, who's in the bankruptcy process? So what's your ability to obtain your leased equipment without having to call the sheriff? Again, the attorney answer is, it depends. It depends on whether or not your equipment lease is truly a lease versus a document that creates a security interest in that equipment by the debtor. Those instances are frequently where you have, after so many payments, they own it. Or after so many payments and they're responsible for all of the upkeep, the debtor owns that piece of equipment. So if it's a true lease and they're just renting it from you, the debtor can either assume, reject, or assume and assign the lease to a third party. What does that mean? So if a debtor files for bankruptcy and there is a lease, then I can either say, yep, I'm going to keep the lease, I'm going to keep operating with that piece of equipment, and that's it. So they've reaffirmed that lease. Reaffirming the debt is a process where typically the debtor will reattach their personal obligation on that debt, or reattach the company's obligation on that debt. Kind of an easier example is if I have a car lease and I were to file for bankruptcy and I signed a lease assumption, then I would, even though I received a bankruptcy discharge saying Carina doesn't have to pay any of her debt, I would be reattaching my personal obligation to make those monthly lease payments on my car. The other option that a debtor has is to reject the lease. Say, nope, I don't want this lease anymore. I don't want this equipment. I'm done. Or the debtor can assume the lease, so similar to that process of reattaching, but then assign it to some other third party. You see this sometimes in reorganizations where a branch of the corporation has been, or the entity has been sold off. If it's actually a security interest, so if your equipment lease has actually been determined to be a financing arrangement by the court, then it'll be treated as a debtor-creditor relationship, but on a secured level. What about a creditor's ability to obtain payment for certain supplies that they've provided? So, as we alluded to earlier, when someone files for bankruptcy, there is an automatic stay or an automatic hold that goes into effect. That automatic hold prevents collection activity. A lot of times, by way of example, you hear of an individual filing for Chapter 13 bankruptcy protection to stop a foreclosure. Or you hear of an individual filing for Chapter 7 bankruptcy in order to stop a garnishment. So the automatic stay is the legal process that stops that collection activity. So it's an automatic order that is issued when somebody files by the bankruptcy court. So, as a creditor, can you attempt to collect a debt after you know that somebody has filed for bankruptcy? The answer is no, even if they have your supplies. So if you've delivered me supplies, I turn around and file for bankruptcy protection, but I'm supposed to owe you those funds, you can't collect it from me unless you want to violate the automatic stay. Unfortunately, as a creditor, you still must perform all of your obligations to a contract. But you cannot attempt to collect those pre-petition debts. So you deliver me supplies. The next day I turn around and file. I still haven't paid you for my supplies, but because I owed you money from the day before, that is a pre-petition debt, you can't come after me for it. But if you contractually owe me goods in the future, you still have to supply those goods. As a note, sellers of goods may have the ability to have their debts or their claims classified as administrative. And this is only in certain circumstances, but it's important to be aware of. Because if you can be classified as an administrative debt or claim that has to be paid by the bankruptcy plan or plan of reorganization, then you're higher on that totem pole for payment. You're getting paid first. The whole goal is to get paid first. So outside of bankruptcy, what are the types of other options? And there are options. So there's debt settlement, which is typically a pre-litigation negotiation that occurs between a debtor and a creditor, in which both parties are agreeing to either take or provide a a lump sum payment on the debt in exchange for a lesser amount being owed, or payment plan over a time frame, so that the debtor has a chance to pay the debt. The creditor at least gets paid without having to expend litigation costs, and it's an agreement that the two would enter into outside of litigation. The next other option would be a legal methodology. So in order to get paid, a creditor might file what's called a breach of contract action, or an unjust enrichment action, or some other legal claim. So an unjust enrichment action, for example, is where you potentially don't have a contract, and you're saying, well, I gave them a bunch of goods and they said that they would pay me. They haven't paid me, so they've received a benefit that I conveyed upon them without paying me. They've been unjustly enriched. And so that is a type of legal action that one might file with when there is no contract involved. Another type of option that a person who would be a debtor would consider is called an assignment for the benefit of creditors. That still involves the courts. But what you're doing as that individual or that entity is that you're assigning all of your assets to what's similar to a receiver or an assigner, where that individual or entity is going to be administering all of your assets and liquidating them for the benefit of your creditors. So it's really similar to what it sounds like. Assignment for the benefit of creditors. You're assigning all of your assets to someone else to liquidate and then provide to your creditors on a potentially prorated basis. Another option is dissolution. We spoke about this briefly earlier. So this is a legal process in which a corporate entity is wound up or wound down, depending on how you want to view it. So the entity would file dissolution paperwork with the state of Michigan, depending on the process that's either outlined in its articles of organization or bylaws. And once the dissolution paperwork is filed with the state of Michigan, then very similar to the assignment for benefit of creditors, any assets that were on hand would be liquidated and then dispersed to any of the creditors, or in accordance with the paperwork for either the LLC or the corporation. Another type of bankruptcy alternative is a receivership. This is where a receiver is appointed, typically by the courts, in order to run generally a business who is not running things properly. So there's typically some creditor or maybe even a member or shareholder who is saying, hey, this isn't being run properly. We need somebody else to come in, look at the books, and see what's and see what's being done so that we can properly run this business. So what are some of the key takeaways? One of the biggest things that I tell people is that the more proactive that you are, the more options that you have. The earlier that you start to look at potential problems and not ostriching yourself and just ignoring it, the better that you will be and the more options that you will be. You start to engage that creditor as if you are a debtor early in the process to say, hey, I'm having issues making payments on these invoices. Let's work this out. You may very well be in a better situation than if the creditor has been hounding you for 6 months for payment, and now any type of good business relationship you had has been nullified. So the reverse of that is also true. As a creditor, if you see that one of your clients is having an issue making payments or is slow paying, reaching out to them in the beginning might be helpful. So you still have options, whether or not you're a creditor or a debtor. Another good thing about potential early action is that when you're communicating with the other side, you can potentially avoid lawsuits. So you can get into some early resolution. Now, caveat to that is don't go making promises that you can't fulfill, because then you'll get into some other types of legal claims, such as fraudulent misrepresentation. Also, bankruptcy can be a very effective tool in either reorganization or limiting liability and for the creation of a fresh start. And that's the whole purpose of the bankruptcy laws. Bankruptcy was created in order to allow the debtor a fresh start. And so it is a very effective tool, and it can be for either the debtor or the creditor. As a creditor, it is very important to reach out to somebody to know what type of legal rights and remedies that you have if you do have a customer or a supplier or an individual who has filed bankruptcy. So I want to thank you for your time. Again, my name is Carina Kraatz. I am a principal at the law firm of Kitch, Drutchas, Wagner, Valitutti, and Sherbrook. Thank you.